Thank you, Amy. It's good to be here. People have been talking behind this image of James Madison, but I want to start, since we are in Philadelphia and at the University of Pennsylvania, by invoking the most subtle and I think in most ways the most skeptical of the framers, Dr. Franklin, and ask, what would poor Richard say? And along those skeptical lines, my answer to the question that's been asked of us is everything but yes. That is to say, every variant of not yes. So my first answer is simply no, for the reason Steve said at the end. No constitution can ensure justice for all. Constitutions aren't that powerful. They're not capable of doing that. Countries may be able to do that, but their form of government and the substantive provisions of their basic law don't accomplish that. Other political forces accomplish that. And it's important to have realistic expectations about what constitutions can and can't do. Having said no, my next non-yes answer is, I don't know. And I don't know for two reasons. One is, like a number of people who have spoken, I am one of those who believe that originalism is a false category. There is no such thing as originalism per se. An easy way to see that is to think about the hoary contrast between original intent and original public meaning, and to realize that in both of those phrases, original is the adjective, and the really important part is the noun. And the major divisions on questions of interpretation are about the identity of the object of interpretation. The particular temporal marking can be important, but it's a separate question, and I don't think much unites people who indicate that temporal marking as the one they want. So in a sense, there's no such thing as originalism. The other reason I don't know is, like everybody else on this panel, I've been thinking about the meaning of the text of the 14th Amendment for a long time. And the more I think about it, the harder it gets, and the less well I understand it. So I just get more and more confused. My last answer that is not yes is, so what? Or, it doesn't matter. Some variant of, don't worry about it. And the particular variant of don't worry about it that I want to urge is a response to the argument that we've heard mentioned a couple of times, that whatever variant of originalism one is considering should be ruled out because of its unacceptable consequences. And that is the argument I want to meet and reject. And to do that, I'm going to demonstrate that the owl of Minerva flies only at night, and now explain to you what the whole conference has been about, by organizing the sequence of questions that one has to ask and answer in order to do constitutional interpretation. Question number one is, what is the fundamental law in this country? And it is vital to see that the answer, if one is a serious follower, say, of H.L.A. Hart's understanding of the nature of law, the answer may or may not be that document that people have been holding up. And there are very powerful arguments that it is not. That the law, basic law in America, is more complicated than that. David Strauss is a proponent of that view, as I understand it. So is Richard Fallon. That's question number one. If you answer question number one by saying it is in fact the form of words, it is in fact the document, the next question, question number two, is what is the object of search when one sets out to interpret a written legal text? And it is to this question, what are interpreters looking for? What is the meaning? That the different forms of originalism offer answers. So original public meaning, original semantic meaning, non-original semantic meaning, original intention. Those are all answers to question number two. Once you've answered question number two, there's then question number three. How to turn that into answers to particular problems, say cases or other practical problems. And that's where questions like the difference between interpretation and construction and application arise, question number three. Question number four is, once the courts and the other parts of the American legal system have built up a body of practice, precedent, which is partly judicial, partly non-judicial, what is the authority of that as such? I'm going to talk about question number two. And my first point about question number two is that if you want to answer that question, all right, what is the object of inquiry when you're trying to identify the meaning of a legal text? The mode of answering that is to ask questions like, okay, well, how does communication work? And are communications necessarily communications from particular human beings? And if so, what does that tell us about what the object of inquiry must be? It must be perhaps in some sense a mental state of the people who are communicating. That kind of answer to the question leads to what's called intention and may or may not lead to original intention. And the answer to that question might get more refined when one realizes that this is a specifically legal document and that among language practices in general, there are specifically legal language practices. And so maybe that fact will tell you more about what the answer is to the question, what is one looking for when you say, what is the meaning of an authoritative legal text? But the natural way of answering those questions is to ask about language practice, because this is the premise, is that these words are the supreme law. There's no natural place there to ask about consequences. But nevertheless, it is common to say, and you've heard it suggested, that certain consequences that follow from certain answers to question number 2 are simply unacceptable. That is especially common with respect to the 14th Amendment, and that's the reason I am more or less talking about the topic of this panel, at least as I understand it. Certain results, it said, under some kind of originalistic reading of the 14th Amendment would be very bad. Standard examples include allowing segregation in public schools and allowing sex discrimination with respect to civil rights, although not with respect to at least some political rights due to the 19th Amendment. So the argument from consequences says that even if you've answered the question, gotten what you thought was the answer to question number 2, characterization of the object of inquiry, and I'll call whatever somebody thinks the answer to that is alpha. Alpha can be rejected if the consequences are very, very bad. And the first point I want to make about the consequentialist argument is, if the reason for saying that is the one you normally hear in talking about the 14th Amendment, that so understood the legal text would permit, under alpha, would permit something bad to happen, that consequentialist argument, it would permit something bad to happen, is in fact highly unpersuasive for this reason. It's very, very unlikely that any plausible constitution of the United States or any other country would forbid all bad things. A constitution is going to grant substantial discretion to political decision makers. And inevitably, a constitution will grant sufficient discretion to political decision makers that they can do something really bad. For example, the question has been raised, is the Constitution a suicide pact? I don't know, but I know in a sense it is a homicide pact. In the sense it is entirely consistent with the Constitution, for example, for the United States to declare war on Canada, and for Congress to make it the President's obligation to invade and subjugate Canada, which would be an act of grave injustice. And indeed, it was entirely constitutional in the 19th century when the United States declared war on Mexico, and many Americans at the time believed that was a grave injustice. U.S. Grant was one of the people who believed that was a grave injustice. So it seems to me that the argument from consequences that has any bite at all is not the one that says that alpha permits bad things, but that alpha forbids good things. That the Constitution, say, read in an originalistic fashion with an originalist answer to question number 2, says no Social Security, no paper money.